$100 million of fine is an amount of fine that has been rarely given in Canadian history. I challenge everyone to find a fine that is higher than that for a criminal offense by a company.
Section 750 of the Criminal Code does not apply, so we are free to bid as normal. So this guilty plea does not prevent construction or any other entity of the group to bid on public contracts.
The corporate criminal case that led to one of the biggest political stories of the year is now settled. Today, SNC-Lavalin pleaded guilty to fraud relating to work it did in Libya. Other charges were dropped. As a result, the company will pay, as you heard there, a $280 million fine and get 3 years of probation. But, as you also heard there, it is free to bid on contracts both here and internationally. Earlier this year, the Prime Minister's office was accused, of course, of interfering in the case so that SNC-Lavalin could avoid prosecution. That ignited a political firestorm in turn. The CBC's David Cochran followed the story very closely all year. You're back, end of 2019. Looks like things are, at least on the criminal side of things, wrapped up.
Yeah, it's a fascinating end to this, because this is a story that really dominated the year, dominated Parliament for the first part of the year, derailed careers. If you look at Jerry Butts, Michael Wernick, Jody Wilson-Raybould, and Jane Philpott, and it really kind of diminished the Prime Minister. And in the end, Vashi, SNC-Lavalin essentially got what it wanted. I mean, this is not a defer prosecution agreement, but it's kind of the next best thing. There's an admission of guilt. They get a big fine, they get a period of probation, but there's no ban from federal contracts, which is really what this was all about, at least in the political argument. So after unleashing this furious lobbying campaign to have a prime minister pressure a justice minister and setting in motion really this scandal that upended the government, they did it the old-fashioned way. SNC-Lavalin's lawyers worked out an arrangement with prosecutors to come to this plea bargain that was announced today, and essentially, in terms of their ability to operate, they got the outcome of a deferred prosecution agreement without having to get an actual deferred prosecution agreement.
I just want to reiterate for our viewers, because the big thing, that the concern around the DPA back in February, back in March, was that they wanted it, or it should be awarded to them so that they could avoid having to be banned from bidding on those contracts, because those contracts are very important to the survival of business.
Right.
That was what we were
The argument
told.
in favor of SNC and a DPA
Right.
was essentially let them make amends, let them admit to their wrongdoing, let them pay the fines and do restitution, but let them keep operating, because they felt that the ability to bid on federal contracts was core to their essential work. And all the doomsday scenarios of 9,000 jobs disappearing if they were unable to do this or relocating was all put into that political cocktail. Turns out there was another path.
Right.
Prosecutors sat down with defense lawyers and they worked it out.
And tell me a bit about since it did cause such a big controversy here, what's the reaction been like politically?
Well, Prime Minister Justin Trudeau today had an interview with the Canadian press. He sat down with them, and we've acquired some video from the Canadian press. And in this interview, Trudeau was asked, was it all worth it? Take a listen.
I think obviously, as we look back over the past year in this issue, there are things we could have, should have, would have done differently had we known. Had we known all sorts of different aspects of it. But you don't get do-overs in politics. You only, do the best you can to protect jobs, to respect the independence of the judiciary, and that's exactly what we did every step of the way.
So that very last part of that clip, I think Jody Wilson-Raybould, it's safe to say, would disagree with that, though she did say today she's pleased with this outcome. She put a reaction on Twitter. I want to show you one of her tweets. She says, 2019 began with very public questions about the rule of law in our country. I am glad to see it end with that principle being upheld. The justice system did its work. So that's sort of the central point there, because she had said from the beginning that she wanted the fate of SNC-Lavalin left to the prosecutors to decide. Keep the politics out of it, keep the politicians out of it. And in the end, that is what happened based on all the public statements we have. So procedurally, she got what she wanted. And in terms of the outcome, SNC-Lavalin kind of got what it wanted, because it continues to be able to operate and bid freely on federal public contracts. The people who got hammered here and diminished were really Justin Trudeau and his government.
How does this work going forward now?
I think David Lametti is probably breathing a sigh of relief, because the Justice Minister and Attorney General will face no more questions about whether he gives a DPA. I think one question now politically is, what do the opposition do? They now have control of committees, so they try to do further inquiry and inquisition into this, and what would the Bloc Québécois do, for example, in that circumstance. We've seen a bounce in SNC-Lavalin's stock price since this was announced, up over around 20%. So that doomsday scenario of the job losses that a lot of people said was over the top, we'll never know, because all of that's now been avoided.
All right. Thank you, David. Appreciate the update. The CBC's David Cochran. To help us understand the potential consequences of this deal, Jennifer Quaid is here. She's an associate professor of law at the University of Ottawa, and she's joining me in studio. Hi, Professor Quaid. Nice to see you again.
Hi, Vashi. Nice to be here.
It's been a while since all this was going on, and now fast forward a number of months, and we've got this decision. Help us understand, is this basically a DPA light, as some have termed it?
That's an interesting way to put it. I think it depends from whose perspective you look at. If you look at the perspective of the company, I think David's summary pretty much captures it, that in terms of the outcomes, they've gotten the outcomes they were seeking, right, which was, the big one was to avoid debarment, and the secondary one is to sort of put an end to things, to stop the uncertainty. Yes, they have to pay a big fine, but they always, I think, suspected there was going to be an amount they had to pay. And you know, obviously the prosecutors have now on the table, we've got a conviction. This thing has been resolved, and maybe it's not quite the big splash of a verdict after a trial, but you know, criminal trials are uncertain. They're always uncertain. So taking the deal now is something that prosecutors will always consider seriously.
We heard one of the lawyers talk about the severity of the punishment, say, oh, you know, $280 million, that's unheard of. I'm paraphrasing, I don't remember exactly what he said, but basically saying this is very punitive. Would you agree with that assessment?
I have to say that the number is big. There have been, you know, big settlements in other countries. This is big here, right? But we don't know how they got to that number. And for someone like me, I want to understand, well, what's behind that number? Was this a multiplier of the gains that they made? We sort of know that, you know, there's a figure of about 130 million associated with, you know, the fraud. Is there a component of that that's supposed to reflect, you know, kind of a symbolic denunciation of how severe this conduct was, because it involves really high-level executives. It was over a long period of time. We don't really know how it was put together, so it's a big number. But, you know, to argue that it's going to have a deterrent effect and it's going to have all these consequences, I think just a round number with no explanation is going to be harder to sell as being an effective tool.
Is there any way for the public to find out what is behind that number?
Well, that's, to me, one of the casualties of the process going this way. I mean, settling through a plea was always an option. It was always a third way. No one was talking about it for a while. Interestingly enough, the deferred prosecution agreement style would have offered a lot more information, because it's put in a certain way. There's a certain number of items you have to address, including a detailed fact description, and there has to be an admission of responsibility. Here there's a plea, but the plea comes from a subsidiary. It doesn't come from SNC-Lavalin or SNC-Lavalin International.
Can you explain the difference? Well,
it means that from their perspective, they don't have a criminal record. They didn't do anything wrong. You know, in corporate law, there's a very strict view about separate legal personality between separate incorporated entities. And, you know, so this is not the same as the company pleading guilty. And obviously—
how come they were allowed to do it this way? Well, asking as a not a legal expert, I'm sure it's obvious to you, but to those of us who know what they're charged with and what they faced, and that the prosecutor said we can't arrive at a DPA because of all these reasons, then how were they able to do that?
Well, I think what happens here is you have a deal that's been arrived at that, for reasons that will never be fully revealed, because there's settlement privilege and those negotiations are never going to be disclosed either by the Crown or by SNC-Lavalin, so we don't know exactly what went into making the sausage. And in some ways the Supreme Court has said we don't want, and we can't question what goes into making the sausage if we come to a deal. But I think in this case, in order to get that outcome of no debarment, you had to have a plea that involved a charge that wasn't going to attract debarment, and it was better to have a subsidiary plead guilty. So I think this is the compromise solution. That's what it is.
I feel like for people who who don't know the ins and outs of it, or even for myself looking up from the outside in, it seems there isn't a massive difference between what they were looking for from the DPA and what they got here, other than pleading guilty. They would have had to pay a fine. DPAs are meant to pay a big sum of money as well, right? And they would have avoided debarment with a DPA. So is there a salient difference other than pleading guilty?
There isn't a salient difference, I would say, from the perspective of the company. There's a salient difference from the perspective of the public interest. And that is to say that some of the other things that a deferred prosecution agreement, or remediation agreement as we call it here, have to address is victims. Is there going to be reparations? Have we tried to identify them? Those are line items in the remediation agreement that There's a possibility to say there'll be no restitution or that we are not individually contacting them, but there has to be an explanation as to why. It's a sort of comply or explain provision. There's no discussion of victims here, nothing at all. Maybe they just considered it was too difficult or too hard or just wasn't going to be discussed. I think the other two casualties are the transparency side of it. So the idea that it's not just a transaction between the Crown and the accused, where there's actually an ability for the public to understand what happened. And I think against the backdrop of global attention on corruption and the need to respond to it, it's important to convey the sense that there is an effort to respond in a way that actually will do something, right? And so I'm not saying that the deal wouldn't necessarily achieve the outcome, and in part, we're giving credit to SNC for things they've done in the past and so on, but to not explain it and to not provide the public sort of that transparency is important. And the final thing, which is related to transparency, is that this is supposed to have some pedagogical impact. That is to say, it's supposed to be able to communicate to other companies and other participants in the market, here's what's good, here's what's not good, here's what our expectations are, so that we don't have to conclude a deal with everyone, that there's going to be some learning. Right now, what we have are oral submissions made before a court. I guess you can get a transcript of that, and somebody might put that online, but that's not the same as having an agreement and a judgment that goes through why, this is in the public interest. And I think that's the real loss here.
Yeah, I wonder what the deterrence, you had mentioned the word deterrence, and it kind of dovetails off what you just mentioned is. I wonder what the deterrence is for other companies when you see what David mentioned, a 20% jump in their stock prices immediately following the announcement of this. It's $280 million, that's a lot of money, but is it a lot of money to a company the size of SNC?
Well, I think there's that, but probably in this case, I really think that the SNC case has become a bit of a unicorn, very unusual. Right. All this stuff happened before we had a DPA agreement. There was an effort to try to bring one in place so that they could use it, and we saw how well that worked. But they've had a lot of time to adjust. This deal was not cooked up overnight. And so, when you have time to adjust, expectations in the market have adjusted. Once it became clear that a DPA wasn't going to happen, people moved on. So I would say in some way this is kind of putting the final dot on the I, but I'm not sure how much the market is surprised. They're, of course, reassured and they think, okay, now really we can turn the page. But I'm not sure that this has sort of the bombshell effect that people might expect.
No. Okay. Thank you, Professor Quaid. Pleasure to have you here as always.
Thank you.
Jennifer Quaid, Associate Professor of Law at the University of Ottawa. Earlier this year, the Prime Minister's office was accused of interfering in the case so that SNC-Lavalin would avoid prosecution. That ignited a political firestorm. So does this close the door on that controversy? Kenneth Jewell is a lawyer at Gardner-Roberts and a law professor at the University of Toronto. He testified as a witness before the Justice Committee on Remediation Agreements and was quoted in the Ethics Commissioner's report on the SNC-Lavalin affair. Professor Jewell joins us from Toronto. Hi, Professor. Wonderful to see you as always.
Hi. Great to see you again.
Let me ask you first, the way in which this is being characterized as essentially a DPA but not a DPA, in that the outcome is similar but the mode of getting there is different. Is that accurate?
I think that is accurate. This is, in my view, is an elegant solution, and I think it's DPA through the back door.
What makes it elegant?
Well, it's elegant in the sense that it's a compromise for both sides. It's got advantages for the defense, yes, the SNC-Lavalin Corporation, because as is pointed out, there will be no debarment, and the jobs of innocent folks will be saved. But it's also got some advantage from the prosecution's point of view, because they avoided risk. There was risks in this case that they could have lost, either due to a trial within a reasonable time issue, or the prosecution might not have been able to show that either Mr. Bababwe or Mr. Benassaya were acting inside the scope of their authority. So there was risks on both sides, and I think that this is an elegant solution that is in the interest of justice.
We heard the clip there about the amount of money that the company will be required to pay, $280 million. How does that stack up against other findings? Is this extremely punitive? Is it expected? What is your assessment of that fine?
I think it's in the ballpark. As a comparison, you could look at the Erickson Deferred Prosecution Agreement, although it's not a plea, but it's similar, just negotiated last week. That was a $1 billion case with a $520 million fine and disgorgement of $540 million for a total of $1 billion. But in that case, it involved conduct in 5 different countries, stretching over 17 years. So 280 is, in my view, in the ballpark.
Let me ask you. Oh,
sorry, go
ahead.
was just going to say, what's interesting, though, is that I haven't heard a lot about restitution or disgorgement.
Yes.
And that's the missing piece here.
Would that be to victims of the crimes, do you mean? Or
Yes. So, and in the United States, what will often happen is that money will go to the SEC, which is in not only to victims, but it's really going as part of disgorgement of profit. And the concept of that is you're not only paying a fine, but you're losing any of the profit that you made from the illegal deal.
And so we don't have any transparency around that at this point.
It appears that there is no figure that has been set for that number. So 280 is the number.
So would it be, if there was restitution, would it be in addition to the $280 million or of that pile?
So if you follow the U.S. model, it would be in addition. It appears that they have not gone that route in Canada.
And what do you take from that?
Well, I think part of it, I take 2 things. Number one, it may have been difficult to assess the nature of the claims, although there was a lot of, the allegation was $130 million in Libya. But I think the other thing was this is a compromise, right? And in a compromise, nobody's happy. As I say, you've got the balancing here of risks to the prosecution, risk to the defense, and in a compromise, it's a compromise. And so it's never perfect. And I think that the fact that the number wasn't bigger and it didn't have restitution reflects the risk analysis that was done by the prosecution.
One of your colleagues, Professor Jennifer Quaid, was on the show earlier, and she highlighted that there was perhaps less transparency in this instance than there could have been under a DPA. So, for example, we don't know how they arrived at that $280 million figure or why. Do you think there's, what is your take on the lack of transparency around this decision, and will it potentially impact deterrence or anything else, or is this de rigueur?
Well, I have a lot of respect for Professor Quaid. And I share her view. I think that although I think both processes, both plea deals and the negotiation of deferred prosecutions do occur initially behind closed doors, and they're both subject to court approval. So in that sense, they're somewhat the same.
Mm-hmm. Can you explain also how, because the big part of the story months ago was whether or not this company would be able to continue bidding on these infrastructure projects, particularly in this country. That was where the line was drawn between the 9,000 jobs, the health of the company. How does this decision and this agreement allow for that? I mean, the idea that we were, and this is, again, I'm not a legal expert, but that we were sort of foisted upon was that if they are convicted, they will no longer be able to bid on said projects. Now, they are convicted of something or they've pleaded guilty to it, but they're still able to. How does that work?
Okay, Vaji, excellent question. Thank you for asking that. So there's a list of offenses that make a company subject to debarment. What's happened in this case is that the corruption charges and the charges under the CFPOA, the Corruption of Foreign Public Officials Act, those charges have been withdrawn. What's left is fraud. Now, fraud, this is where it gets tricky. Fraud is a listed offense, however, only when it's fraud against Her Majesty or the government of Canada. In this case, the plea relates to fraud that has occurred in Libya. And the way I read the technical listing of the offenses, I believe it is that clever pleading, frankly, that is avoiding the debarment. Now, I was in support of a deferred prosecution agreement, and I think that it's the right thing not to put innocent people out of work, but it's a somewhat clever way that they've done this, and that's why I say it's a deferred prosecution through the back door.
All right. I appreciate your insights as always and your explanation. Helpful as usual. Thanks, Professor Jewell. Great to see you.
Thanks for having me.
Kenneth Jewell, lawyer at Gardner-Roberts, and of course a law professor at the University of Toronto. SNC-Lavalin has pleaded guilty to a charge of fraud and will be fined $280 million and be put on 3 years probation. The remaining charges against the engineering giant were stayed, and it is free to bid on contracts both here and abroad. So after months of lobbying and the blowing up of the Prime Minister's inner circle, who or what paid the greatest price? Time for the Power Panel. Joining in from Toronto, Amanda Alvaro of Pomp and Circumstance. Alongside her, Vicky Machama, Culture, Society and Critical Race Editor at The Conversation. Not too far away from them, Hill and Knowlton's Melissa Lantzman and Brad Levine of Council Public Affairs. Over in Montreal, Danielle Turp, former Bloc MP and PQ-MNA, now law professor at the University of Montreal, joins us. Hi, everyone.
Oh.
Nice to see you. Okay, Amanda, help me make sense of all this. All of that, months and months, and here we are. Essentially, the company gets what it wants, and there's no DPA in sight.
We were talking during the break, and we were kind of like, it's like the DPA equivalent of a non-DPA.
Yeah,
I mean,
DPA light. Yeah.
It's DPA light, exactly. And I think it's interesting because it allows us maybe to start having a conversation in the country about whether or not we should be pursuing DPAs and what at their core, without the sizzle, without the heat, everything that sort of surrounded this SNC scandal, why DPAs work. I mean, what's missing from this is that in a DPA, and I think the law professor who was on earlier said this, is like the rehabilitation and some of the other pieces that come along with it, the transparency, and there was merit to that, but it got lost in what became, embroiled in a scandal that lasted many weeks and ultimately many months. So I'm hoping that at the end we have this opportunity to talk about it in a bigger, broader, intellectual way. I also think, we saw the stock starting to rise, and there's good news for this company, but more importantly for the workers in the company. This was about, in many ways, the Liberal government wanted to save jobs. They wanted to make sure that the share price wasn't plummeting. They wanted to protect shareholders, and this is now the outcome, and hopefully this proves is the first step to moving forward.
That's what they said they wanted to do, for sure. I'm not sure everybody believed them. Vicky, what do you think? What do you think the consequences of this are? Do you think this ends the political talk around the subject?
I think in some ways it adds to a growing sense of discontent, and maybe if it's just amongst the legal class around how some of these legal tensions are meant to be dealt with. I mean, one place to look at it is how we enforce corruption or the foreign practices of Canadian companies. How do we do that here? And the question of whether this government is going to do that or wants to do that is still sort of hanging in there. I think this ruling doesn't necessarily incentivize them to do more, but it doesn't necessarily say that they shouldn't do anything. I think it's something that they'll wear forever, and so they're probably looking out for the next Canadian company that might resurface some of these questions of whether or not the Attorney General and the Minister of Justice should be called to step in on behalf of Canadian companies accused of crimes elsewhere. I think that's still surfacing in all of this. Like Amanda says, maybe we have a conversation around DPAs to have. I don't think that, based on some of Canada's practices elsewhere, that conversation's done.
Yeah, I'd be shocked though, politically, Brad, and I wonder what you think, if this government decided that they want to bring up the specter of DPAs again and start discussing them. And just to the point that Amanda made, I mean, I think that there might have been an environment in which that kind of discussion could have been had in the past, prior to all of this. But what we've seen through the Ethics Commissioner's report, et cetera, was that really the introduction of it as a tool in legislation happened at the request of SNC. And it was tied, at least, to maybe on its own there's a lot of merit to it, but it became so entangled with SNC specifically that I imagine having that discussion would be pretty difficult in the near future.
Yeah, well, that's very true. They not only did the legislation be introduced at a time when SNC was up on these charges, but it was buried in a budget implementation bill, an omnibus bill, where there wasn't many argue a clear hearing as to what the purpose or the value of a DPA was.
And SNC had gone to the finance minister's office to say, put it in that bill.
Right, and now this is all behind it. So today, what today actually, I can see that every kind of cast member of this saga is going to claim some victory, right? So Trudeau gets, SNC is not forbidden to do new bids on public works at the federal level. SNC gets to stay whole, even though it's got a fine with it. It's pled guilty. Jody Wilson-Raybould can say that the justice system, as she's been saying all day, the justice system outside of the DPA, was served. Justice was served outside of what she claims as interference. So every cast member in this saga is going to claim that they've won, or that this is now there. But I would submit that if DPAs are going to be a tool in the future that are credible and are clear, as they are in other countries, in this country, there's going to have to be something there. So as long as that, the DPA was in place, and before the crimes that a future corporation is going to be, brought in charges of, then I think it's a credible one. But only when you rip the Band-Aid off and actually have a DPA are you going to make the process clear and credible to all Canadians. But today is a day where everyone's going to claim victory and that they won at the end of the day. The real issue on the political side of things is, how much damage did Trudeau do to himself over the last year when in fact we now learn that all is for naught.
He still won the election, Melissa, right? So when you're assessing that question, how do you do so?
Well, he absolutely won the election. That's not to say that he didn't withstand damage from this one. And if there isn't a loss of 9,000 jobs tomorrow in Quebec, then this might have been all for nothing. Look, I think Amanda's right in saying that this is the most, non-DPA DPA that could have happened, and everybody gets to run the victory lap. The government gets to say that the justice system works. Jody Wilson-Raybould gets to say, I told you so. The public prosecution's office got the guilty verdict that they needed because this might have not qualified for a DPA, and SNC's stock price goes up. So did we learn anything? I'm not sure. Should we have a broader conversation about sort of what corporate plea deals actually mean in Canada? Absolutely, but under the guise of SNC, that's never going to happen.
And I think also Vicky's point is a good one, Danielle. I'm wondering what you think. The idea of sort of a broader conversation, yes, about DPAs, but also about how Canadian companies act in other countries.
Yeah, I agree. And Canadian companies should learn a lesson from that. And there's all kinds of international commitments not to use corruption when you're dealing with other countries and their civil servants. So I do hope companies, learn about things and how to do and not to do things in the near future. But, on Mr. Trudeau, he might have not lost the election, but he didn't win an election with a majority, which he could have done if that had not happened, if he had not handled this issue and made it become a scandal. But there's a lot of relief. What's important is that 9,000 people will keep their jobs. This company will stay in Quebec. It won't be dismantled, and it will be able to bid. So, and that's important for people. This is a great relief for workers of SNC-Lavalin. It's good news.
And quickly, let me just follow up with you, because we kept hearing throughout this whole thing that it was being perceived very differently in Quebec. How is today's news being perceived in Quebec?
Well, I think it will be well perceived because it's about jobs. Mr. Trudeau's right about that. It's about jobs, good jobs, engineers, well-paid jobs here that make our economy work and grow. So I guess people will be happy. But, I agree with the professor you interviewed. She was very good, by the way.
She's
very
great,
interesting,
yeah.
very clear, and I appreciated how she was able to inform us. But there's an issue of transparency. Mm-hmm. That's what I don't like about this whole thing. We don't know anything of how and why this deal was reached, really, and why is it $280 million? That is something that should be more transparent. This process should be more transparent.
Hi, I'm Vashi Capellos, host of Power in Politics. See more of our show by subscribing to the CBC News channel or click the link for another video.